appearing in this matter with the following. My Lord, in this matter, I appear with Senator Daniel Manzo.
Present, my Lord.
Your name, please.
My name is Kibe Mungai. I thought I'd said it, my Lord. Kibe Mungai. Sorry. I appear in this matter, my Lord, with Senator Daniel Manzo.
Present, my Lord.
Mr. Ndegwa Njiro.
I'm present.
Honorable Jerry Maina.
Present, my Lord.
Mr. George Sankimpa.
Present, my Lord.
Mr. Andrew.
Mr. Kibe.
Yes, oh, sorry.
We are recording.
You are recording. Sorry.
Can you start from Dan Manzo?
Dan Manzo. Mr. Ndegwa Njiro.
Present, my Lord.
Senator Honorable Jerry Maina.
Present, my Lord.
Mr. George Sankipa.
I'm present, my Lord.
Mr. Andrew Muge. Mr. Gachagua Ruta.
Present, my Lord.
And Mr. Kenneth Matiba, who is on the way, and Professor Odada. Professor Odada.
Present.
And Kenneth Matiba is on the way. My Lord, we appear in this matter that continues to be referred as Kerugoya, petition number A015 of 2024, that appears to have been filed on the same day
So you are here for which party?
we appear for the petitioners in that.
Lords, to your leadership, this petition E015 2024, Kerugoya file. Again, we appear for the first interested party, that is the Deputy President of the Republic of Kenya, in this E015. My Lords, again, let the record capture and show that council appearing for the first interested party appear under protest. Council are as follows: Paul Mwite, Tom Acharia, Elisha Ongoya, Faith Waigwa, Victor Swanya, George Wandati, and John.
Can we have that again?
Yes, I'm sorry. From what point, my Lord?
From yourself.
Paul Mwite, Tom Macharia, Elisha Ongoya, Faith Waigwa, Victor Swanya Ogeto, George Wandati, and John. At the appropriate time, we will be going into the grounds and basis for appearing under protest.
My Lord, before there were also certain clarifications that I would like to be given before the hearing for today. Direction for today's hearing can be given.
My Lord, before we start today, moves on that file, are there other files, especially file number petition E572, 2024, is it before the bench? We'll take programs of the files which are before the court and that you can raise any issue.
My lords, may you kindly equally confirm whether E509, which was consolidated with E522, is before the bench. One reason, Your Lordship, is that the bench was specifically constituted for that purpose.
Petition E13 of 2024, High Court of Kerugoya, Thomas Kimozo Maingi, petitioner versus Deputy President of Kenya, respondent, and the Honorable AG.
Well, that matter is not before the court.
Your Lordship is being called, it is the call that you know whether it is before the
We had a
We also want to know whether it is before this.
My Lord, and my ladies, kindly, with your kind permission, I would also want to seek clarification for my own petition which I have filed, petition number E567. I had information that that file was also coming up before you this morning, and I would like to know whether the same is before you, and if so, whether you can also proceed with it.
When was it filed?
It was filed on the 18th of October 2024, and it came up before Honorable Justice Mamuye, who gave directions that it should come up actually tomorrow, and I believe that is part of the reasons why there is protest in this matter. And then I was informed that it's coming up today, so I also need clarification.
May it please the court. My name is Dr. Eboso. I'm a petitioner in E541 of 2024, a petition that was filed on 8th of October, and a petition in which we got directions on 16th of October, directing that it be brought before the Chief Justice for this bench traces the same issues as the issues that were consolidated, and I'm appearing in person with Ms. Ivy Wang, the second petitioner, and we were seeking clarifications with regard to directions on that file, because as we can see, the files that were filed on 17th of October, and which directions were given, and the bench was constituted. So we expected that the matter would be mentioned together with this one today. Thank you.
Lord, with utmost respect, this honorable court is a court of record. And the record is very, very important. My Lord, Your Ladyship, we heard the court assistant call out petition E13 of 2024, and she mentioned the word Kenyata. That is the file that was called. And in order for the record of this code to be systematically accurate and easy to follow, may I, with respect, ask that we get clarity on this file that was called out, E13/24 of Kenyata, before we go to the other matters. And perhaps it is for this honorable court to clarify which files, one by one, are before this honorable court. This
Senior Counsel Paul Mutembei, we are giving you time to talk. You see, everybody wants to talk. There will be a time for us also to talk. So I've heard.
Thank you.
For this morning, for the purposes of hearing this morning, the applications which are before the court are application number E0113, which was consolidated in Kenyata before it arrived here with E0114. 0114. Then we have application number E0115, also from Kenyata. That is application before this court. And then we give direction on those applications. And then E565. Those are the three matters which are before this court and in which the Honorable the Chief Justice has constituted this bench for hearing and determination. There are articles of constitution of this bench in the court. So the three matters before the court are E565, E015, E0113, and E014. Those are the files and petitions, applications before this court. And those are the applications on which this bench has given direction pursuant to this bench being duly constituted. So any other applications which we are talking about, we have not cited them. Maybe they are yet to reach us, but for the purposes of today's hearing, we have these three petitions or applications.
Your Lordship, we welcome it, and perhaps also to state for record that we also appear in E015 in protest. But further that, Your Lordship, kindly confirm that the number that is now registered in the matter that came from Kenyata is E015. And that is important, Your Lordship, because of the purposes of administrative transfers of files. Because what was at Kenyata, Your Lordship, was E015. Does it therefore mean that that file has not yet been integrated into the Nairobi files? And if so, then how do we appear to proceed before you, and how was the matter that we shall raise other issues? just confirm on the question of the integration of that file in the Nairobi files, because the last file that we have should be 565 as at Friday. Are we dealing with the matter in Kerugoya or in Nairobi?
Let me deal with that. Lord, for the purpose of A572 of 2024.
That file is not before us.
That's all I'm only saying. I have had the directions of the bench. The file is not before you. But I have instructions for the purpose of the one to take that petition was filed on 18th of October. The same day, the Kerugoya file were filed. All the directions in all these files that have been taken to a graveyard is that none of these files of ours are borders. The reason as to why Kerugoya files before the learned judges is purely because they have orders to stop the swearing in of the deputy president-elect. The CJ could not have selectively decided to have only one file before you, my lord. This is a trial of the judiciary. It is a trial that goes to the root cause of whether there is impartiality.
Mr.
Yes, my lord.
Mr. Omari.
Yes, my lord.
The file you are addressing us, we have said, is not before us. And the files which are before this court are the files in which this specific bench has been empaneled.
Thank you, my lord. Allow me to mourn. Because the questions I'm raising are very pertinent, that there are files selectively brought before you, but there are others.
Mr. Omari, we wouldn't know that because, as you understand, we only deal with matters in which we have been empaneled. We do not empanel ourselves.
Thank you very much. The empanelment authority has heard me loud and clear. Thank you.
Well, I had indicated this honorable court that there will be at least 3 clarifications.
Just a minute, Mr. Omari.
Now, I think we need to get something right. I want to clarify how these files are before this bench this morning. The 3 files which were filed in Kerugoya, that is 13, 14, and 15 of 2024, had some interim conservatory orders issued by the court. Further to the issuance of those orders, the learned judge made further orders requesting the Honorable Chief Justice to empanel a bench. Those files were transmitted on the basis of that order to the Honorable Chief Justice's office on the 18th of October 2024. On that very day, the Honorable Deputy Chief Justice empaneled this bench to hear those matters. Thereafter, applications were filed online. I think you are all aware that we are operating online. Applications were filed online. When those applications were filed online, those are the ones which this bench gave directions for these matters to appear before us today. That is why you are here, and that is the trail, that is the paper trail as to why we're here this morning. So I reiterate the position taken by the presiding judge that we will not be comfortable dealing with any other file, even if it's related to this file, which we did not give directions for it to appear here today. So I think we can now proceed on the basis of that clarification.
Thank you, Judge.
My Lord,
just a minute, please.
Perhaps just to add that it's the numerous other petitions that are coming up.
Yes, my Lord, I believe now I can be able to make the clarification. Yes, my Lord, I believe now I can be able to make the clarification. We are starting with the immediate background that we need to make these clarifications, and we take into account.
Let us finish with quorum first. There's a quorum in E013, which was consolidated in Kergoya with E014. Just take quorum on that file.
Your Lordship is terribly something wrong. And I believe it is important for us to put things into proper perspective. Because when you call the matters, E13 was not part of what was called. I've not heard it perhaps from the court. Your Lordship, in E015, there has never been a consolidation. To the best of my knowledge.
What are you talking about consolidation? Nobody has talked about any consolidation. These files have not been consolidated. I think that is the next process we'll be going into. Nobody has talked about any consolidation. If you look at the record, you will find that the directions for today's hearing are given specifically on each and every file. There was no consolidation of any matter. No matter has been consolidated. So let us not dwell on things which really are not before the court. Now matter has been consolidated. Let us proceed from there. If you want to apply for any files to be consolidated, that is okay. As we speak now, there is no consolidation. The directions from this court were very specific on 3 different files.
My Lord, I'm well guided, but when Justice Mrima was giving the clarification, I never heard him clarify whether the Kerogoya file has been integrated into the Nairobi system. Because we cannot be dealing with a file that is reading Kerogoya. Because of course, if there is no integration, Your Lordship, then there is a rat that is made.
Let me answer you. You said that record speak for himself. And for record, matters which came from Kerogoya came with their own record. And the record states here that the matter herein is consolidated with petition E014 of 2024 and the same to be delivered in the Chief Justice for empanelment of bench in terms of the ruling in petition E014 of 2024, a copy of which shall be placed on this file. So your own matter coming from Kerogoya was already consolidated. Those proceedings which took place in Kerogoya consolidated these 2 files. So let that not be an issue here, please. On the directions issues on 11 by Judge Richard Mongo, these were the directions. The petitioner in E014-2024 to serve their amended petition on all parties. Similarly, the petitioner in E013-2024 to serve their petition on all parties. Respondents to the petition to file their responses by noon of 17th of October 2024. Given that the files are being routed to Honorable Chief Justice forthwith, the party's response to the amended petition and petition E013 of 2024 may be filed in Kerugoya under the Kerugoya case tracking system online, whereupon they shall be forwarded to Nairobi. So these proceedings took place in Kerugoya. So this court has not consolidated any matter. Petition number E14, E014, and petition number E013 are hereby consolidated. The parties who appeared before the Kerugoya court were given those orders. Those were your orders.
And with your permission, presiding judge, the reason why Nairobi has not opened another file to put together all the files from Kerugoya is this. Going by the orders which were issued by Kerugoya court, there was a specific order that because of the transmission, parties will still file their documents under the Kerugoya CTS, that is the court tracking system. We had to hold on to that so that not to disadvantage any of the parties until we appear today. Those are some of the things we will deal with here and make orders to the Honorable Deputy Registrar to formalize that. So there should be no cause for alarm. We will put everything into its place.
I presume now we may now raise the issues that you want to raise, particularly arising from the issues in Kerugoya. And I
We
do
will
not
then
know.
proceed and take quorum on it. They were consolidated, so we will not take further quorum on this matter.
The Attorney General, I don't know, I have indicated to the court and I need to raise some clarification. You had read your subject. It doesn't override my right to represent my client. Can she then say her piece? I say mine.
Now, which matter are we now dealing with?
We have 0115. We have 0115.
My Lord, I wanted to say that
Yes.
the only matter they were filed before impeachment and they have taken over to the government.
I think they do.
We have E15.
E15 has to.
But E13 and E14, although from Kerugoya, they were filed before impeachment and they have no conservative member.
I hope I have then been heard without further appearances. My Lord, my Lord, I'm leading the number of advocates in this matter from Kenyaga, E015.
Kerugoya 15.
Yes, Kerugoya 15.
Yes.
Yes. My Lord, the clarification that I seek to raise emanates against this general background. The first one, my Lord, is that there was a sitting on Saturday, which the court has since explained how that sitting occurred. With regard to that sitting, my client wrote a letter to the Honorable Chief Justice, which has been placed on record in an affidavit in an application before you, that protesting, amongst other things, that the practice in which a Saturday sitting would be convened for purposes of hearing the executive and organs of government that have violated fundamental rights is a practice that is prohibited under the 2010 Constitution. That letter is on the record. We do not trust that the Honorable Chief Justice could actually do that because she knows the history about what used to happen. But we now learn, Your Lordship, that you are convened by the Honorable Lady Justice Will the Deputy Chief Justice. But arising from that are one, a legal issue and a matter of Article 150. My Lord, under the law, and we do this every day, I practice public law every day. Arising from that issues of the communication, speaking for 015, we expected that the general procedure would be, and that is what the orders implies, and required us to come on Thursday this week, that when the Chief Justice appoints a bench, she will do it in writing as required under Article 47 of the Constitution. We would be given the number of those judges and the day that they will be sitting. This day, we have not received officially, because even when the sitting happened on Saturday,
My Lord, may
I think I have a right to raise those issues.
Let's give my fellow Mungai time first.
Mungai, Boigai.
I just wanted for good order, my
Okay,
Lord.
is that a clarification, Mungai?
My Lord, I am Mungai. I believe he will speak in response as soon as I'm done. Let me finish.
My Lord, I wanted to assist the court because my learned friend has, I believe, filed a substantive application so that the court does not hear speeches in vacuo. My learned friend should identify what application he is ventilating so that even we taking notes know what we should be responding to. That's all I wanted
My
to
Lord,
say.
Professor Boigai was a former Attorney General. I respect him. He was also my teacher, my professor for criminal law. But my Lord, the point that I wish to make is that I am acting for specific clients today, and that's before the court. I should be having silence. He will respond. And I've indicated that we have formal applications. What we are raising is an issue that is arising from what Judge Murima has indicated. We could not put it earlier in an application. So if I may proceed, my Lord, the issue is this, that we expected a notification in writing that these judges have been appointed and they would sit on a particular day. All those notifications, including in cases of abductions, have been that the first sitting by a bench has been on a working day. All applications, and I'm aware of this as a fact. So then the first clarifications would be, on what basis would, in an application by the executive, be convened on a Saturday? That is a substantive issue because of the second reason that our background that we are giving. My Lord, under the 2010 constitutions, the constitutions provide for the Bill of Rights. My Lord, under the former constitution, under the former constitution, we used to have a practice in which we had unofficially a bill of immunities for the state, where the constitution, the state could conduct its business on weekends and outside court sitting hours. But because of that reason, that's why I'm saying, this, we are sitting here pursuant to the orders made last time. And my Lord, we are also sitting here pursuant to an order made by the Honorable Chief Justice. My Lord, for purposes of Article 165, I believe it's 4 of the Constitution, the powers of the Chief Justice to appoint a bench is a substantive power. It is not administrative. This power, my Lord, cannot be shared by the Deputy Chief Justice or with the Deputy Chief Justice. And because it cannot be shared with the Deputy Chief Justice, it is the reason why I say two things. that our instructions is that we must move this court immediately to set aside that order on the basis of its unconstitutionality. The Chief Justice of Kenya cannot appoint anyone, any judge, pursuant to Article 165(4) of the Constitution. And we shall place here the Deputy Chief Justice a formal applications. Issue number 2, my lords, arising from that.
Let us be discharged the directions of empanelment.
My lord, I am saying that we shall make a formal applications to discharge that order made by the Deputy Chief Justice. That's what we are indicating. My lord, number 2, and it is implied in the applications for disqualifications that we have filed. Number 2 is that we raise the issue that for purposes of the Saturday sitting and today's sitting, and the thing is out there in the streets and the Republic of Kenya, is that a special bench would be appointed for purposes of vacating the orders that were made. My lord, I have a lot of respect for all of you that have appeared before previously. But my lord, pursuant to my instructions that would be the case, 3 issues worries us. Number 1, we had a sitting on Saturday, the practice of the former constitution, where the executive enjoys special privileges. Number 2, my lord, is that we have confirmed that the only files that are before you are files where we have interim conservatory orders. So that, my lord, and it is important that this issue is speak for the wananchi and with a clear conscience. 2 things. My lord, the first thing would be this, that if this matter is going to be conducted like today on the basis that only those matters where the Attorney General is itching to set aside conservatory orders are the ones that are going to be heard, there would be something wrong because other cases that are even officially before you and probably assigned to you by the actual Chief Justice of Kenya are still pending. So what was this where you prioritize the state as it used to happen those days before we had a new constitution? Issue number 2, my lord, is this, the issue of bias. And this is bias by the honorable,
I think, Mr. Mugai, you are going beyond ordinary comments. If you have an application which addresses those prayers or those issues, I think you...
Let me raise the other issue that does not have to do with those prayers. The last issue, therefore, would be this. If assuming that cases that were supposed to appear before you are cases that came after the impeachment, my lord, there are about 4 matters, one of them in which I appear. And this is a fundamental issue. That matter is coming on Thursday. Okay? An express order of the court that has not been set aside. The question would be this, for purposes of good order, and for purposes of us making this application, why would it be difficult, even for this bench, to order all cases, because that is the right to equality under